advisement. We now turn to the last case on this morning's docket, and that is case number 104503, State of Kansas v. Jason Wade Schaeffer. And before counsel begins arguments, I wanted to refresh everyone's recollection. I had mentioned at the outset of this morning's docket at 9 o'clock that on this last case, Justice Lukert would be recused, and she would be ably replaced by the distinguished jurist to my right. This is the Honorable Dexter Burdett, a longtime district judge in Wyandotte County, the 29th Judicial District. Judge Burdett has fully read all the materials on this case. He'll listen very carefully to your arguments this morning, as the rest of us will, and he'll fully participate in our case conference this afternoon and in the ultimate resolution of this case. And with that, let me turn and thank Judge Burdett for helping out the Supreme Court on this matter.
Thank you very much for the warm welcome, Chief Justice, and my thanks to the rest of the court. As a sitting district court judge, I really appreciate this singular opportunity to participate in the appellate process. Again, my thanks.
All right, thank you, Judge. Counsel, you may proceed.
If it pleases the court, I'm Nancy Ogle here on behalf of Jason Wade Schaeffer. I'd like to reserve, if possible, 3 minutes for rebuttal.
3 minutes is granted.
I'm sure the court is well aware that I filed a brief on Mr. Schaeffer's behalf and raised 2 issues, and the court was kind enough to allow him to file a supplemental brief in which he raised an additional 10 issues. The first issue I raised had to do with whether this court has jurisdiction. I raised that merely because I know that it can be raised at any time, and rather than wait for the court to ask me to brief that, I briefed that in the opening brief that I filed on Mr. Schaeffer's behalf. The state, in its response to my brief, had no objection to Mr. Schaeffer being allowed to pursue an appeal several years, well, I think over 16 years after his sentencing based on Ortiz. And unless you have some questions on that issue, I will move on. Okay. I will focus the rest of my time on the remaining issue that I raised, which was whether the district court imposed a sentence based on impartiality, prejudice, or corrupt motive. And then, if time allows, I'll move on to one of the issues raised by Mr. Schaeffer in his supplemental brief, that being the use of the district court of his psych examination done at the Larned, which had not been entered into evidence, and the state did not offer any basis for, or foundation for it to be considered by the court. Moving to the issue of whether his sentence was based on partiality, prejudice, and corruption, Mr. Schaeffer was charged with 4 counts based on events taking place. When he was 16, he entered a plea, which is why so many of the issues raised on appeal are limited. He was charged with kidnapping, murder, aggravated robbery, and an unlawful weapons charge. This was also, his sentence occurred in May of 1994, which means his sentencing does not fall under the sentencing guidelines and the grid that we now use, but the indeterminate sentencing under 214501. He was given a maximum sentence within that indeterminate sentencing statutes for each of the 4 sentences or 4 crimes that he had pled guilty to. So at 17, he was sentenced to life for the kidnapping, life for the murder, 15 years to life for the aggravated robbery, and a 1 to 5 sentence, all of them to run consecutive. And the reason Mr. Schaeffer is raising the issue and asserting that the district court's sentence is based on partiality, prejudice, and corrupt motive is based on primarily the comments that the district court judge made at the time of sentencing. And just as an example, the judge kind of impromptu stated if Schaeffer had a gun at the sentencing hearing, the judge was sure that he would use it on someone. The district court judge also made comments about the fact that Mr. Schaeffer had lived in a town which was, I believe, the judge's hometown. The judge had relatives living there, and he feared for their lives just knowing that in the past Mr. Schaeffer had lived in that town. The district court judge also made comments regarding how Mr. Schaeffer and his co-defendant should not be allowed to live. And although the sentencing guidelines didn't apply, he mentioned that the hard 40 would not be a hard enough sentence for Mr. Schaeffer. He also would urge the parole board to never let Mr. Schaeffer see the light of day. And this all, the sentencing was happening when Mr. Schaeffer was 17. As pointed out in the briefs that were filed by the state and myself, the approach or analysis of whether there was partiality, prejudice, or corrupt motive is governed by an analysis or standard that's applied when judges should recuse themselves. And there's a two-step process in that, and the first does not require a showing of actual prejudice, or bias or prejudice, but it's the judge's duty to recuse when their bias or their impartiality could reasonably be questioned. And it's certainly Mr. Schaeffer's position that the comments made by the district court judge at sentencing would indicate that there's at least a reasonable question of whether he's being impartial.
He got the maximum consecutive sentence that was allowable under the law. He didn't go beyond that.
Correct.
Did he? So it's just your position that he didn't exercise discretion in considering a lesser sentence because of his comments, which relate to the bias that he has in the case. Is that basically your position? That he just gave him he could have done more, didn't do that, but he gave him the maximum because he had this preconceived or a notion that he might be dangerous even in court?
Well, I mean, I'll admit that he was not given an illegal sentence, that he was merely given the max. I shouldn't say merely when you
given
get
the maximum sentence.
Life sentences. But yes, and it shows that he didn't give any consideration to something less than the maximum. Whereas had he recused or not, been impartial, another judge may have at least given that some consideration. The second step in the analysis is on an objective standard of showing bias or prejudice and whether the probability of bias and prejudice is so high as to be constitutionally too high to be constitutionally tolerated. And so Mr. Schaeffer's position is that at sentencing, not only can the comments made by the judge be used for the first step to at least bring into question, reasonably bring into question the impartiality of the judge, but it also goes that step higher to show actual bias or prejudice that's so high that it couldn't be tolerated under the Constitution. Moving on, unless you have questions.
In your brief, you initially make the comment that the underlying factors or the underlying facts are not of great importance to the issues raised on appeal. Really, don't the underlying facts go to the heart of the matter that you're appealing?
Well, I would say once he pleads guilty to the various facts or to the various crimes and agrees to the factual basis, and the reason I used the affidavit that I did was because Mr. Schaeffer agreed to those set of facts, that once those facts are established, then they aren't of great importance as to what his sentence would be.
Weren't there back then, in 214606, sentencing factors that a judge, in fact the state argues here that the judge actually considered those statutory sentencing factors, and that's the whole heart of this appeal, whether the sentence was imposed pursuant to appropriate consideration of sentencing factors or whether it was the product of partiality, prejudice, or corrupt motive, isn't it? And what Judge Burdett's saying is, how can you consider those sentencing factors vis-a-vis partiality unless you consider the facts of the case?
Well, our position is, considering the facts of the case and the crimes charged that he's pled to, then when the judge starts making comments about you shouldn't get to live or survive, and if you had a gun here, I'm sure you'd kill somebody, even if he ceremonially goes through all the steps for the analysis of determining a sentence, he's still showing his bias and prejudice through those statements. Just real quick, I want to mention that in Mr. Schaeffer's issue regarding the use of the psych eval by the district court judge, in the state's response, the state says that his lawyer did not object. Actually, the lawyer did object in the sentencing hearing from page 10 to 12. And I will admit, he objected as to whether it was in evidence and could be relied upon by the judge. There isn't a specific objection as to whether Mr. Schaeffer was Mirandized, which is a separate second issue related to the psych examination. Anything?
Any further questions of counsel before she takes her seat? Thank you, counsel.
Thank you.
The state appears by Assistant Solicitor General Natalie Chalmers. I'm not sure I have anything to add to my brief, so I would just open to any questions you might have. No questions? state would ask you to
Since-
affirm. I'm sorry.
Since you reviewed your brief before you came here, would you like to leave us with what you think is its most impressive point?
I think regarding the sentence of his judge's discretion here, the facts of this case are, as the district court judge described, horrendous. Yes, this kid was only 16, but as the district court repeatedly pointed out, he showed absolutely no remorse for his actions. He had already committed 7 crimes by the time he was convicted of this particular offense. It was a senseless killing. The district court simply did not abuse his discretion or show undue prejudice. Everything that the district court said was specifically learned by the facts of this case, and it wasn't him being otherwise.
And the facts of the case supported the fact that he should not live.
That was not a wise statement by the district court.
Or that his relatives lived in the hometown and he feared for his relatives.
Well, the relatives living in the hometown came from the fact of the PSI. I think when you have a killer that is willing to kill for no particular reason, even though the killing could have been avoided, you're not just going to be fearful for your own family members, but in general, your sense to protect the community would kick in. I'm not saying that his choice of words was perfect by any means, but probably reasonable people could disagree about whether or not this man deserves to live.
Well, but the point is, every defendant is entitled to have an objective determination based on the facts without having fear for family or other extraneous factors.
But the sense of community or the safety of the community is not an extraneous factor. It's crucial to deciding whether or not this man should ever be released from prison. And the judge found that he was a danger and should never be released to the full extent of the law, which was the maximum sentence given in this case.
He actually went a little farther, didn't he? And basically suggested that he would oppose any parole requests.
Yes, he did do that.
Any further questions of counsel? Any further presentation?
No, thank you. The state would just ask that you affirm Mr. Schaeffer's convictions and sentence in this case. Thank you.
Thank you, counsel. You had reserved 3 minutes.
Other than to, which I didn't say when I was up here earlier, that I'd asked the court to find the sentence imposed was a product of partiality, prejudice, or corrupt motive, and to ask this court to vacate Mr. Schaeffer's sentence and remand with instructions for resentencing. Unless you have questions, I don't have anything more to add.
Any further questions, counsel? I see none. Thank you, counsel. Thank you both for your arguments this morning and also this afternoon. The court will take this matter under advisement. This time the court is in recess until 9 o'clock tomorrow morning.